Welcome, jesters. Today's lesson is compound nouns. The White House, red tape, the Golden Girls. These are compound nouns in English, an adjective and noun combination that are considered lexically as one term or one word. You cannot split the two without fundamentally losing the meaning of the compound noun. Do you know what is not a compound noun? Due process. Due process is not a thing. It is not a specific thing. The Constitution could have been written, or the Founding Fathers could have written in the Fifth Amendment, the process to which a person is due under the law, and it would mean exactly the same thing. When the Constitution says due process, that is a placeholder. It is an abstract. It is merely a requirement of government to follow the processes a person is due under the law. The Constitution also does not define due process in any way. It does not. It mentions it, but it does not define it. Do you know who defines the processes to which someone is due under the law? It's not the courts. It's not the Supreme Court. It's certainly not the district court. It is Congress. Congress alone has the authority to create the processes to which any person is due under the law. And Congress can create whatever kind of process it wants. If somehow we manage to pass a law and get it signed by the executive that people with green hair are summarily deported to North Korea, that's the process. That's it. Just go round up all the green-haired weirdos and send them off to North Korea, and guess what? They got their due process. Because that's the process created by Congress. So why is this relevant today? It's because the Alien Enemies Act does not include any provision for notice or appeal, which means no notice or appeal is required because that's the process Congress created. And the Supreme Court has no authority to change that. They don't. They absolutely do not have the authority to change a process enacted by Congress. It really is that simple. Now, some people are saying, well, Congress hasn't really defined every federal procedure. No, they haven't. The rules for federal criminal procedures and civil procedures right now are, in fact, defined by the court, by the Supreme Court, or actually by a conference of judges overseen by the Supreme Court or something like that. But the power for them to do even that comes from Congress. And the Rules Enabling Act that Congress passed in 1934, allowing the court to set these procedures, to actually create these specifics of the process that someone is due. Anything the court does is allowed by the Congress, but Congress can still act on their own to create whatever processes they want, the process to which someone is due. In fact, the Rules Enabling Act says the court shall not abridge, enlarge, or modify any substantive right. So by congressional act, the Supreme Court cannot change substantively any process created by Congress. And this includes the Alien Enemies Act, right? So you know what? It's funny because if you listen or read some of how our lefty friends are talking about, the current constitutional crisis and how some people are not getting due process, or we have to bring them back so he can get due process. Yes, you can tell that they are using that improperly as a compound noun because they don't actually know what it means. And what's even crazier is I have seen excerpts from rulings and judgments or things handed out by the court that also use due process as a compound noun, which suggests that some of these judges, even ones on the Supreme Court, don't know what due process actually means. The same kind of judge that might also not know what a woman is. I'm not joking. Anyway, yes, so due process is the process to which someone is due under the law, and only Congress can create that process, and they can create any process they want, and the courts have to follow it. No judge, no Supreme Court can change that. You know I'm right.